I never thought I would end up in a legal battle with a homeowners association that had absolutely no jurisdiction over my property. But here I was, standing in my driveway, holding a certified letter threatening me with daily fines of $500. My name is Yates Anderson, and I own a beautiful 3-bedroom cottage on the outskirts of Asheville, North Carolina. The property sits on 2 acres of land that my grandfather purchased back in 1967, long before any housing development existed in the area. I inherited it 5 years ago when he passed, and after doing some renovations, I started renting it out on short-term rental platforms to help cover the property taxes and maintenance costs. The income was decent, the guests were mostly respectful, and I genuinely enjoyed meeting people from all over the country who came to explore the Blue Ridge Mountains. Everything was going smoothly until about 3 months ago when the Riverside Meadows Homeowners Association decided they had a problem with my business. The irony was thick enough to cut with a knife because my property was not, had never been, and would never be part of their development. Riverside Meadows was built in 2015, a sprawling subdivision of cookie-cutter houses that bordered the eastern edge of my land. We shared maybe 100 feet of property line, nothing more. The letter in my hand was signed by Patricia Cunningham, the HOA president, and it informed me in the most condescending language possible that I was in violation of their community guidelines regarding short-term rentals. According to this document, I had 30 days to cease all rental activities or face escalating fines and potential legal action. I read the letter 3 times, each reading making my blood pressure climb a little higher. They cited Section 7.4 of their covenants, conditions, and restrictions, which apparently banned any property within a half-mile radius of Riverside Meadows from operating as a short-term rental. The audacity was stunning. They were literally trying to extend their authority beyond their own property boundaries, and onto land they had no legal connection to whatsoever. I immediately called my lawyer, Marcus Chen, who had helped me with the estate transfer when I inherited the property. He listened patiently as I read the letter aloud, and I could hear him typing in the background. "Yates, this is absurd," Marcus said when I finished. "They have zero authority over your property. Your land predates their development by almost 50 years. You are not a member of their HOA, you have never signed their covenants, and you are under no obligation to follow their rules." "So what do I do?" I asked, still staring at the letter like it might spontaneously combust. "First, do not respond directly to them. Let me draft a formal response explaining that your property is not subject to their governance. Second, keep operating your rental as usual. They cannot enforce any fines against you. And third, document everything. Save all communications. Keep records of your rental income, and if they escalate this, we will be ready." I felt a bit better after talking to Marcus, but I had a sinking feeling this was not going to be the end of it. I knew the type of people who ran these HOAs. They were usually retired busybodies with too much time on their hands and an inflated sense of power. Patricia Cunningham, from what I had heard around town, fit that description perfectly. 2 weeks later, I was proven right. I arrived at my property one morning to prepare for new guests checking in that afternoon, and found a large wooden sign planted right at the end of my driveway. It read, "Warning, illegal short-term rental operation. Riverside Meadows HOA does not approve this business." I stood there for a solid minute, just staring at this sign on my property. They had actually trespassed onto my land to put up their ridiculous warning sign. I took several photos from different angles, then called Marcus again. "They are escalating," I told him. "They put a sign on my property." Marcus was quiet for a moment. That is trespassing. Do you want to file a police report? I thought about it. Part of me wanted to just rip the sign out of the ground and throw it in the woods, but I knew documentation was important. Yeah, let me call the sheriff's office. Deputy Williams arrived about an hour later. He was a middle-aged man with a weathered face and a patient demeanor. I showed him the sign and explained the situation. He took photos, wrote up a report, and helped me remove the sign from my property. I know Patricia Cunningham, Deputy Williams said as we loaded the sign into his patrol car. She has called us about violations in her neighborhood at least once a week for the past 2 years. Parking infractions, noise complaints, people having the wrong color mailboxes. She means well, I suppose, but she takes the HOA thing way too seriously. This is different, though, I said. This is not her neighborhood. This is my property that has nothing to do with her HOA. I understand that, and legally you are completely in the right. But between you and me, she is not going to let this go easily. These HOA types, when they get something in their head, they are like dogs with a bone. Deputy Williams was unfortunately correct. 3 days after the sign incident, I received another certified letter. This one informed me that I had been assessed a fine of $15,000 for continued violation of HOA regulations. The letter also stated that if I did not pay within 14 days, they would place a lien on my property. I immediately forwarded everything to Marcus, who responded within the hour requesting a meeting. I drove into Asheville the next morning and sat in his office while he laid out our options. This has crossed into harassment territory, Marcus said, leaning back in his chair. They cannot fine you. They cannot lien your property, and they are opening themselves up to significant legal liability. I think it is time we send them a cease and desist letter and make it very clear that if they continue, we will pursue legal action against both the HOA and Patricia Cunningham personally. Will that work? I asked. Marcus shrugged. With reasonable people, yes. But I am getting the impression that Patricia Cunningham does not fall into that category. Still, we need to establish a clear paper trail. I will send the letter today via certified mail and email. The cease and desist letter was thorough and professional. Marcus laid out the facts. My property was not part of Riverside Meadows. I had no contractual relationship with their HOA. Their attempts to fine me were unlawful. The sign placement constituted trespassing, and any further harassment would result in a lawsuit seeking damages and attorney's fees. For about a week, things were quiet. I had several groups of guests come and go without incident. I started to hope that maybe, just maybe, Patricia had realized she was in the wrong and backed off. Then the Riverside Meadows HOA board called an emergency meeting, and they invited me to attend. The email invitation came from Patricia herself. It was polite but firm, requesting my presence at the Riverside Meadows Community Center on Thursday evening at 7. The agenda item was listed as discussion of short-term rental issues affecting community quality of life. I forwarded it to Marcus, who advised me not to go alone. If you want to attend, I will come with you, but honestly, Yates, you have no obligation to meet with them at all. I want to go, I said. I want to look these people in the eye and explain that they cannot bully me off my own property. Thursday evening arrived cold and drizzly, typical April weather in the mountains. Marcus and I drove to Riverside Meadows and found the community center easily enough. It was a modern building with large windows and expensive landscaping, all maintained by HOA fees that I had no part in paying. Inside, about 30 people were already seated in folding chairs arranged in rows. At the front of the room, a long table held 5 board members, with Patricia Cunningham sitting dead center. She was exactly what I expected. A woman in her late 50s with perfectly styled blonde hair, designer glasses, and an expression that suggested she had just smelled something unpleasant. When Marcus and I walked in, the conversations around the room died down. People turned to stare at us like we were criminals entering a courtroom. We took seats near the back, and I tried to keep my expression neutral. Patricia called the meeting to order with a sharp rap of a gavel. She went through some standard business first, approving minutes from the last meeting and discussing landscaping contracts. Then she got to the main event. "Now we come to a matter of great concern to our community," Patricia began, her voice carrying that particular pitch of manufactured authority. "As many of you know, there is a property adjacent to our development that has been operating as a short-term rental. This has led to increased traffic, noise disturbances, strangers in our area, and a general degradation of our community's character and safety." I felt Marcus put a hand on my arm, a silent reminder to stay calm. "We have attempted to address this issue through proper channels," Patricia continued. "We sent notices to the property owner explaining our community standards. However, these communications have been ignored, and the illegal rental operation continues." "Excuse me," I said, standing up. All heads turned toward me. "I am Yates Anderson, the property owner you are discussing. I would like to clarify a few things." Patricia looked like she had bitten into a lemon. "Mr. Anderson, this is not an open forum. If you wish to address the board, you need to submit a request in writing." "Miss Cunningham, with all due respect, I am not a member of your HOA and I am not subject to your rules of order. You invited me here to discuss my property, so let me be clear. My land is not part of Riverside Meadows. It was purchased by my grandfather in 1967, decades before your development existed. I have never signed your covenants. I am not bound by your regulations, and what I do with my property is absolutely none of your business." The room erupted in murmurs. Some people looked shocked, others angry. Patricia's face turned an impressive shade of red. "Mr. Anderson, property values are everyone's business. Your rental operation brings transients into our area. We have families here, children who play outside. We cannot have strangers constantly coming and going." "Strangers like the people who bought houses in your development?" I asked. "Because last I checked, everyone was a stranger until you met them. My guests are tourists, families, professionals in town for work. They are no more dangerous than anyone else." A man in the front row stood up. He was probably in his 60s, wearing an expensive polo shirt and khakis. "I live on Riverside Drive, right near your property line. Just last week, one of your guests had a loud party that went until midnight. We could hear it from our backyard." "Did you call the sheriff's office to report a noise violation?" I asked. The man hesitated. "Well, no, but it was still disruptive." "So you are complaining about a noise that may or may not have violated any actual ordinances, that you did not report to the proper authorities, and you want me to shut down my business because of it?" Marcus stood up next to me. "For the record, I am Marcus Chen, Mr. Anderson's attorney. I think there is a fundamental misunderstanding here. The Riverside Meadows HOA has no legal authority over Mr. Anderson's property. Any attempts to fine him, restrict his use of his land, or otherwise interfere with his property rights constitute harassment and potential grounds for legal action." Patricia slammed her gavel down. "We have the right to protect our community. Our CCRs clearly state that no property within a half-mile radius can operate as a short-term rental without board approval." "Your CCRs can state whatever they want," Marcus replied calmly. "They only apply to properties within your development that have signed those covenants. You cannot unilaterally extend your authority to surrounding properties. That is not how property law works. Another board member, a thin woman with severe features, leaned forward. We consulted with our attorney, and he assured us that we have the right to enforce community standards in the surrounding area to protect property values. Then your attorney is either misinformed or lying to you, Marcus said bluntly. I strongly encourage you to get a second opinion, because if this continues, the HOA and its board members individually could be held liable for harassment, defamation, and intentional interference with business relationships. The meeting devolved into chaos after that. Multiple residents stood up shouting questions and accusations. Patricia kept hammering her gavel and demanding order. Marcus and I eventually left, walking out to scattered boos and a few supportive nods from people who apparently understood how property rights actually worked. That went about as well as expected, Marcus said as we reached our cars. Now we wait and see if they are smart enough to back down. They were not smart enough to back down. The following Monday, I woke up to an email from the booking platform I used for my rental. My listing had been flagged for violating local regulations and temporarily suspended pending investigation. Someone had reported my property as operating illegally. I immediately called the platform support line and spent 2 hours being transferred between departments. Eventually, I reached a supervisor who explained that they had received multiple complaints from the Riverside Meadows HOA claiming my rental was in violation of community regulations. They provided copies of the HOA's CCRs and insisted the platform was required to suspend my listing until I could prove compliance. But I am not part of that HOA, I explained for what felt like the 100th time. Their regulations do not apply to me. I understand, Mr. Anderson, but we have to take these complaints seriously. If you can provide documentation proving your property is not subject to these regulations, we can review your case. I spent the rest of the day gathering documents. I scanned my property deed showing the purchase date of 1967. I got a letter from the county assessor confirming my property was not part of the Riverside Meadows development. I included Marcus's cease and desist letter to the HOA. I compiled everything into a single PDF and uploaded it to the platform. Meanwhile, I had to cancel reservations for the next 2 weeks, which meant refunding deposits and losing income. Each cancellation email I sent made me angrier. Patricia Cunningham and her HOA board were costing me real money now, interfering directly with my business. Marcus advised filing a lawsuit. They have crossed the line from annoying to actionable. They are intentionally interfering with your business relationships. We can sue for damages, which would include your lost rental income, and we can seek an injunction preventing them from contacting your business partners or making false statements about your property. Do it, I said. I am done playing nice with these people. The lawsuit was filed in Buncombe County Superior Court 3 days later. We sued the Riverside Meadows HOA as an entity, Patricia Cunningham individually, and the other 4 board members individually. The complaint laid out everything: the unauthorized fines, the trespassing sign, the false reports to the rental platform, and the ongoing campaign of harassment. We sought compensatory damages of $50,000 and punitive damages to be determined by the court. When the lawsuit was served, all hell broke loose. Patricia called me directly, which was a mistake on her part since I recorded the conversation. North Carolina is a one-party consent state, meaning I only needed my own consent to record. Mr. Anderson, this lawsuit is outrageous, Patricia said, her voice shaking with anger. We are simply trying to protect our community. You are the one operating an illegal business. Miss Cunningham, you should not be calling me directly. All communication should go through my attorney. But since you did call, let me be absolutely clear. My rental is not illegal. Your HOA has no authority over my property, and every action you have taken constitutes harassment and interference with my business. We have every right to enforce standards in our area, she insisted. No, you do not. You have the right to enforce standards within your development, on properties that are part of your HOA. My property is not part of your HOA and never will be. You are costing me money with your false complaints, and I am going to make sure you pay for every dollar I have lost. Are you threatening me? No, I am telling you what my lawsuit already says. Your actions have damaged my business and you will be held accountable. Now please stop calling me and direct any further communication through your attorney. I hung up and immediately sent the recording to Marcus. This is gold, Marcus said when he called me back. She basically admitted to the interference on a recorded line. This strengthens our case significantly. The HOA hired a law firm out of Charlotte to represent them. Their attorney, a man named Douglas Freeman, sent a response to our complaint that was equal parts defensive and aggressive. He argued that the HOA was acting within its rights to protect community interests, that their CCRs were legally binding on surrounding properties, and that my lawsuit was frivolous and intended to intimidate concerned citizens. Marcus tore the response apart in his counter-filing. He cited case law from North Carolina and other states establishing that HOA authority is strictly limited to properties within the development that have signed the covenants. He pointed out that Riverside Meadows had not existed when my property was purchased, making it impossible for my grandfather to have agreed to their rules. He included the recorded phone call, where Patricia admitted to their enforcement actions. While the legal process ground forward, things on the ground got worse. Someone in Riverside Meadows created a Facebook group called Stop Illegal Rentals in Our Community. The group's description named my property specifically and encouraged members to leave negative reviews on the rental platform, report my property to various government agencies, and contact my guests directly to warn them about safety concerns. The online harassment was vicious. People I had never met were posting lies about my property, claiming it was a haven for parties, drugs, and criminal activity. They posted photos of my cottage with scary captions suggesting it was dangerous or unsanitary. One person even created a fake review claiming they had stayed at my property and found bed bugs, which was completely fabricated. I reported the Facebook group and the fake reviews, but the damage was spreading faster than I could contain it. Even after my rental listing was reinstated on the platform, bookings dropped dramatically. People were reading the negative comments and choosing other properties. Marcus suggested expanding the lawsuit to include defamation and cyberbullying. They are making false statements that are harming your reputation and business. We can add those claims and increase the damages we are seeking. We filed an amended complaint adding the new allegations and including screenshots of the Facebook posts and fake reviews. We also requested an emergency injunction requiring the defendants to cease all online harassment and remove the defamatory content. The hearing for the injunction was scheduled for early June. Marcus and I arrived at the courthouse prepared with binders full of evidence. Douglas Freeman appeared with Patricia Cunningham and 2 other board members, a man named Gerald Hopkins and a woman named Susan Whitfield. Judge Raymond Martinez presided over the hearing. He was a no-nonsense jurist in his late 60s with a reputation for not tolerating games in his courtroom. Marcus presented our case methodically. He showed the timeline of harassment, the documented property records proving my land was not part of the HOA, the screenshots of online defamation, and evidence of my lost income. He played the recorded phone call with Patricia. He even brought printed copies of the fake reviews, highlighted and annotated. When it was Freeman's turn, he tried to argue that the HOA was simply exercising its rights to protect the community. He claimed the Facebook group was not officially sanctioned by the HOA, and therefore they could not be held responsible for member posts. He suggested that my rental operation was indeed causing problems for the neighborhood and the HOA's concerns were legitimate. Judge Martinez listened patiently, then cut Freeman off mid-sentence. "Counselor, I have reviewed the evidence submitted by both parties. Let me ask you a direct question. Is Mr. Anderson's property part of the Riverside Meadows development?" Freeman hesitated. "Not technically, Your Honor, but it borders the development and affects property values." "That was not my question. Is his property part of the development? Did he or any previous owner sign your HOA covenants?" "No, Your Honor." "Then on what legal basis does your HOA claim authority to regulate his property?" Freeman fumbled through his notes. "Our CCRs state that regulations apply within a half-mile radius." "Your CCRs can state that the moon is made of cheese," Judge Martinez said dryly. "That does not make it true or legally binding. You cannot unilaterally extend your authority beyond your development boundaries. That is basic property law. Your Honor, we are trying to protect our community from the negative impacts of transient rentals." "Then you should petition your county commissioners to pass ordinances regulating short-term rentals. What you cannot do is harass a property owner who is not subject to your authority, make false reports to damage his business, and allow members of your organization to defame him online. This court finds that Mr. Anderson has demonstrated a likelihood of success on the merits of his claims, and that he is suffering irreparable harm from the defendant's actions. Judge Martinez granted our injunction. The order required the HOA and the individual board members to immediately cease all contact with my rental platform and other business partners, remove or cause to be removed all defamatory online content, and refrain from any further harassment or interference with my property rights. The order also specifically stated that any violation would result in contempt charges. Walking out of the courthouse, I felt a massive weight lift off my shoulders. Marcus was practically glowing. "That was about as decisive a victory as we could hope for," he said. Martinez basically told them their entire legal theory was nonsense. Now they have to comply with the injunction or face contempt charges. "You think they will comply?" I asked. Marcus considered the question. "Most people would, but Patricia Cunningham does not strike me as most people. Let us hope her attorney can talk some sense into her." For about 3 weeks, the injunction held. The Facebook group was shut down, the fake reviews were removed, and I stopped receiving harassing communications. My bookings started to recover. I actually had a completely booked July, which would go a long way toward making up for the income I had lost. Then, in late June, I got a call from a couple who had booked my property for the 4th of July weekend. They sounded nervous and confused. "Mr. Anderson, we received a very strange phone call this morning," the woman said. "Someone named Patricia claimed to be from a homeowners association. She told us that your rental was operating illegally and that we could be fined if we stayed there. She said there was an ongoing legal dispute and we should cancel our reservation immediately." My stomach dropped. "Did she give you her full name?" "Patricia Cunningham. She said she was the HOA president." I took down all the details and immediately called Marcus. He was furious. "She directly violated a court order. This is contempt. We file a motion immediately and we make sure she faces consequences. The motion for contempt was filed the next day. We included the couple's statement describing Patricia's phone call and phone records, showing a call from Patricia's cell number to the couple's number. We argued that she had willfully and deliberately violated the injunction and should be held in contempt. The contempt hearing was scheduled for mid-July, but before it could happen, something unexpected occurred. I arrived at my property one morning to find Patricia Cunningham standing in my driveway. She was alone, and she looked terrible. Her hair was disheveled, her eyes were red, and her expensive clothes looked wrinkled. "Mr. Anderson, please, I need to talk to you," she said as I got out of my truck. I kept my distance and pulled out my phone, starting a recording. "Miss Cunningham, you are on my property without permission and you are subject to a court order prohibiting contact with me. You need to leave. Please, just hear me out. I am begging you." Her voice cracked. "The HOA's insurance company dropped us because of this lawsuit. We are facing massive legal bills. My husband is threatening to divorce me because I borrowed against our house to pay for attorneys. The other board members are furious with me. I have ruined everything." I felt a flicker of sympathy despite everything she had put me through. "Miss Cunningham, I cannot talk to you. You need to leave my property and communicate through your attorney." "We do not have an attorney anymore," she said, tears starting to stream down her face. "Douglas Freeman withdrew from the case. He said we were going to lose and he did not want to be associated with it. No other attorney will take us on. They all say the same thing, that we never had a legal leg to stand on. That is what I have been trying to tell you from the beginning." I know. I was so sure I was right. I thought we were protecting our community. Property values, safety, all of that. But I took it too far, did not I? You harassed me, damaged my business, violated a court order, and now you are trespassing. So yes, I would say you took it too far. She covered her face with her hands and started sobbing. "What can I do? How do I fix this? Please, I will do anything." I stood there watching this woman fall apart and felt deeply uncomfortable. Part of me wanted to tell her exactly what I thought of her, to list all the ways she had made my life hell for months. But another part of me just felt tired. "Get off my property," I said finally. "Talk to the other board members. Talk to your attorney or find a new one. Work something out through the proper channels. But do not come here again. Do not contact me directly and stop interfering with my business. That is what you can do." Patricia nodded, wiping her eyes with her sleeve, and walked back to her car. I watched her drive away, then immediately called Marcus to report the encounter. "She is spiraling," Marcus said. "The contempt hearing is in 3 days. My guess is she is panicking and trying to do damage control, but she is just making it worse by violating the order again." The contempt hearing was surreal. Patricia showed up without an attorney, which Judge Martinez immediately noted as a bad decision. She admitted to violating the injunction by calling my guests and apologized profusely to the court. She explained that she had been under enormous stress and had not been thinking clearly. She begged for mercy. Judge Martinez was not impressed. "Miss Cunningham, I issued a clear and unambiguous order. You chose to violate that order because you apparently believe that your judgment supersedes that of this court. That is unacceptable. I find you in contempt of court." He sentenced her to 30 days in jail, but suspended all but 7 days, meaning she would actually serve a week behind bars. He also ordered her to pay $5,000 in additional damages to me for the violation, and to cover Marcus's fees for bringing the contempt motion. Patricia started crying again, but Judge Martinez was unmoved. Deputies led her away to begin her sentence immediately. With Patricia in jail and the HOA in complete disarray, the remaining board members decided to cut their losses. Through a new attorney, a woman named Jennifer Harris, who actually seemed competent, they approached us about settling the lawsuit. The settlement negotiations took about a month. The HOA agreed to pay me $75,000 to cover my lost income, attorney's fees, and damages. They issued a formal apology acknowledging that my property was not subject to their authority and that their actions had been unlawful. They also agreed to send a letter to all Riverside Meadows residents explaining the situation and making clear that I had every right to operate my rental business. In exchange, I agreed to drop the lawsuit and not pursue any further legal action against the HOA or the board members. Marcus thought I should hold out for more, but I was exhausted from the whole ordeal. I just wanted it to be over. The $75,000 would more than cover my losses and let me invest in some improvements to the property. Most importantly, I could go back to running my business without constantly looking over my shoulder. The settlement was finalized in September, almost 6 months after the initial harassment had begun. Patricia Cunningham resigned from the HOA board, and I heard through the local gossip network that she and her husband were getting divorced and selling their house. The other board members either resigned or chose not to run for re-election. Essentially, the entire power structure of the Riverside Meadows HOA collapsed under the weight of their own terrible decisions. My rental business bounced back stronger than ever. The local news picked up the story of the HOA's overreach, and the publicity actually increased interest in my property. People liked the idea of staying at the cottage that had stood up to an out-of-control homeowners association. I was fully booked through the fall and had advance reservations stretching into the next year. One evening in early October, I was sitting on the front porch of the cottage, watching the sun set behind the mountains and enjoying the cool autumn air. A car pulled up my driveway and I tensed for a moment, old habits from months of harassment dying hard, but it was just a young couple, my guests for the weekend, arriving a bit early. "Mr. Anderson," the man called as they got out of their car. "That is me. You must be the Johnsons. Welcome." "Thank you so much for having us. This place is beautiful." "I read about what happened with the HOA," the woman added. "That must have been awful." "It was challenging," I admitted, "but it worked out in the end." Sometimes you have to stand up for what is right, even when people with perceived authority try to push you around. "Well, we are glad you did. We almost stayed in Riverside Meadows, but honestly, after reading about how their HOA behaved, we decided we would rather support your business." I showed them around the property, pointed out the best hiking trails nearby, and gave them my number in case they needed anything. As I drove back to my own house in Asheville, I thought about everything that had happened. The stress, the legal battles, the harassment, all of it had been terrible at the time. But I had learned some valuable lessons. I learned that HOAs could be dangerous when led by people who confused authority with power. I learned that standing up for your rights was not always easy, but always necessary. I learned that documentation and good legal counsel were worth their weight in gold. And I learned that property rights in America still meant something, that you could not simply be bullied off your own land by people who thought they knew better. Most importantly, I learned that my grandfather's old property, the land he had worked so hard to purchase and maintain, was worth fighting for. He had built something lasting and I had helped protect it. That felt good. The rest of that fall and winter passed peacefully. My rental stayed busy, the guests were wonderful, and I had no further contact with anyone from Riverside Meadows. I heard through various channels that the HOA had become much more cautious and restrained under its new leadership. focusing on actual maintenance issues within their development rather than trying to police the surrounding area. In February, almost a year after the whole nightmare began, I received a handwritten letter in the mail. The return address showed it was from Patricia Cunningham, though the address was in a different part of town from where she had lived before. I debated whether to even open it, but curiosity won out. "Dear Mr. Anderson," the letter began, "I am writing to offer you a sincere apology for everything I put you through last year. I have spent the past several months in therapy, working through some issues that I now realize drove my behavior. I was using the HOA as a way to feel important and in control, and I lost sight of basic fairness and legality. You were right about everything, and I was wrong. I cost you time, money, and peace of mind, and I deeply regret that. I also cost my marriage, my friendships, and my standing in the community, which are consequences I deserve. I do not expect you to forgive me, but I wanted you to know that I am truly sorry and that I have learned from this experience. I hope your business is thriving and that you have been able to move past the damage I caused. Sincerely, Patricia Cunningham." I read the letter twice, then set it aside. It was a genuine apology, more honest than I had expected. Did it change what had happened? No. Did it erase the months of stress and thousands of dollars in lost income and legal fees? No. But it was something. I never responded to the letter. I did not feel the need to. Patricia Cunningham had faced consequences for her actions, and she seemed to understand why. That was enough for me. As spring arrived and the mountains turned green again, I focused on my business and enjoyed the steady stream of grateful guests who appreciated the cottage and the surrounding natural beauty. I made some improvements with the settlement money, adding a hot tub on the back deck and upgrading the kitchen appliances. The reviews were glowing, and my calendar stayed full. One warm April afternoon, I was doing some maintenance work in the yard when a man approached from the direction of Riverside Meadows. He looked to be in his 30s, casually dressed with a friendly demeanor. "Excuse me, are you Yates Anderson?" he asked. "I am. Can I help you?" "I hope so." "My name is David Mitchell. I just moved into Riverside Meadows, bought one of the houses on Riverside Drive. I have been reading up on the neighborhood history and came across information about what happened with you and the old HOA board." I straightened up, immediately wary. "Okay." He held up his hands. "I am not here to cause problems. Actually, I wanted to introduce myself and say that what happened to you was completely unacceptable. The new HOA board has been working hard to change the culture in our neighborhood, and part of that is being good neighbors to the surrounding properties. I am on the new board, and we wanted to extend an olive branch." "That is appreciated," I said cautiously. "We are having a neighborhood barbecue next month, and we wanted to invite you. No pressure, and I completely understand if you want nothing to do with us. But if you are willing, we would like to show you that not everyone in Riverside Meadows supported what happened." I considered the invitation. The old me, the one who had just gone through the lawsuit, would have refused immediately. But enough time had passed that my anger had faded into a kind of tired acceptance. "Send me the details," I said. "I will think about it. That is all I can ask. Thank you for even considering it." David shook my hand and headed back toward his neighborhood. I watched him go, thinking about neighbors and communities and the strange ways people interact when they live near each other. I did not end up going to the barbecue. It felt like too much, too soon. But I appreciated the gesture, and I recognized it as a sign that things had genuinely changed in Riverside Meadows. The new leadership seemed to understand boundaries and respect, which was all I had wanted in the first place. As summer rolled around again, marking more than a year since the resolution of the lawsuit, I found myself in a good place. My business was thriving, my property was well maintained and constantly improving, and I had peace of mind knowing that I had stood up for my rights and won. The story of my legal battle had become something of a local legend in Asheville. Other property owners who were dealing with HOA overreach would occasionally reach out to me for advice or just to hear about my experience. I always told them the same thing: document everything, get a good lawyer, and do not back down if you know you are right. One afternoon, a local reporter asked if she could interview me about the experience for a piece on property rights and HOA governance. I agreed, figuring that sharing my story might help others avoid similar situations or give them the courage to fight back if they found themselves facing HOA harassment. The article ran in the Asheville Citizen-Times and was picked up by several state and national real estate publications. It generated a lot of discussion about the scope and limits of HOA authority. Several state legislators even reached out to say they were considering bills to clarify HOA jurisdiction and prevent the kind of overreach I had experienced. I never imagined that standing up for my property rights would turn into a larger conversation about HOA reform, but I was glad if my experience could lead to positive changes. No one should have to go through what I went through, spending thousands on legal fees and losing months of income, because an HOA decided to extend its authority beyond its actual boundaries. Looking back on the whole experience now, I can see it as a strange and stressful chapter that ultimately had a positive resolution. I protected my property, I sent a clear message about legal boundaries, and I came out stronger on the other side. My grandfather's land remained independent and free from outside control, just as he would have wanted. The cottage still sits on its 2 acres, welcoming guests from around the country who want to experience the beauty of the Blue Ridge Mountains. The trees he planted still provide shade, the stream he loved still runs clear, and the view from the front porch still takes your breath away on a clear day. And most importantly, it is mine to do with as I please, free from the interference of people who confused their limited authority with unlimited power. That is worth more than any amount of money, more than any settlement or legal victory. It is the fundamental right that property ownership represents in America, and it is something I will never take for granted again. The last I heard, Riverside Meadows was doing well under its new leadership. Property values were stable, residents were generally happy, and the HOA focused on the things it was actually supposed to focus on: maintaining common areas, enforcing rules within the development, and fostering a sense of community among its members. Patricia Cunningham apparently moved to Florida to be near her sister and start fresh. I hope she found peace and learned from her mistakes. As angry as I was during the worst of it, I do not wish her ill. She was a cautionary tale about what happens when small amounts of power go to someone's head, but she was also a human being who made mistakes and paid a heavy price for them. As for me, I continue to run my rental business, maintain my property, and enjoy the mountains I love. I have new respect for the legal system and the protections it offers to property owners. I have gratitude for the good attorney who fought for me when I needed it. And I have satisfaction in knowing that when someone tried to push me off my own land, I pushed back and won. The story could have ended differently. If I had been less prepared, less determined, or less fortunate in my legal representation, Patricia Cunningham and the Riverside Meadows HOA might have succeeded in shutting down my business. The harassment might have continued until I gave up and stopped renting my property. The false reports and online defamation might have permanently damaged my reputation and income, but that is not what happened. Instead, I stood my ground, fought the legal battle, and emerged victorious. The system worked, property rights were upheld, and justice was served. It was not quick or easy or cheap, but it was worth it. Now, when I sit on that front porch in the evenings, watching the sun paint the mountains in shades of orange and pink, I feel a deep sense of contentment. This is my land, my business, my legacy from my grandfather. No one can take it from me, no matter how official their letterhead looks or how confident their threats sound. The cottage stands as a testament to the principle that in America, your property is your property, and that means something. It means you have rights that cannot be trampled by busybody neighbors with inflated senses of authority. It means you can fight back against harassment and win. It means the law will protect you if you are in the right and willing to stand up for yourself. Every guest who stays at my property, every positive review I receive, every peaceful night I spend there is a victory over those who tried to shut me down. They failed, I succeeded, and life goes on. That is the story of how a homeowners association tried to ban short-term rentals on property they did not control and had no rights to. It is a story about overreach and consequences, about standing up for your rights and seeing justice done. And it is a story with a happy ending, which is more than I could say during those dark months when the harassment was at its peak. I learned that you can fight City Hall, or in this case, you can fight an HOA board. You just need to be right, be prepared, and be willing to see it through to the end. The truth will come out, the law will protect you, and the people who tried to bully you will face the consequences of their actions. So if you ever find yourself in a similar situation, dealing with an HOA or any other organization that is trying to exercise authority they do not actually have, remember my story. Get a good lawyer, document everything, and do not back down. Your property rights matter, and they are worth fighting for. The sun sets over the Blue Ridge Mountains tonight, just as it has for millions of years, and will for millions more. The cottage sits peaceful and secure, hosting another happy family making memories in the mountains. And I sleep well, knowing that I did the right thing, protected what was mine, and proved that justice can still prevail when good people stand up for what is right. That is all any of us can do. Stand up, fight back when necessary, and protect what matters. The rest will take care of itself, one sunset at a time,